Ross Ulbricht's mother, and he was just recently convicted for creating and operating the Silk Road website. And because I'm his mother, I had a front row seat at the trial, which Nick Gillespie of Reason magazine called the most important trial in America. It certainly was a landmark case for the digital age. Unfortunately, only one side got its day in court. Legal analyst for Forbes, Sarah Jong, called it the trial that wasn't. A blogger called it performance art. It certainly wasn't what I thought a fair trial would look like. Now, if you're familiar with the case, no matter what you think about Ross, whether you think he was rightly or wrongly convicted, or is a hero or a villain, I would hope we could all agree that he deserved, and that we all deserve, a fair trial. Ross didn't get one, and in fact, his attorneys have filed post-trial motions to that effect, asking for a retrial. Instead, evidence favorable to Ross, exculpatory evidence, was suppressed, defense witnesses were blocked, and his attorney was hamstrung, so he couldn't effectively cross-examine and establish reasonable doubt. Now, the deck was stacked against Ross in many ways, even before he walked in that courtroom. One of them, not the least of which, was he had one of the most powerful politicians in the United States making this his personal project. Chuck Schumer publicly convicted Ross in an open letter to Eric Holder saying, "Hey, DOJ, congratulations, you got your man." This was pre-trial. This was before evidence was known. So much for innocent until proven guilty. And I wonder how Ross could get a fair trial in New York with Chuck Schumer coming out like that. So the trial itself started January 13th. People were outside protesting what they thought about it. Inside, and they came from several states, inside, it started out pretty much what I expected. The prosecution did their usual bashing, pointing at Ross over and over again. They're really big on the pointing thing. I had noticed that in the bail hearing as well. And then Ross's attorney, Joshua Retrial, got up and dropped a bombshell. And he said, well, actually, Ross did create the Silk Road, but not as a drug site, as a free market economic experiment. And he got out a few months later and passed it along to someone else. And that person, in September of 13, found out that law enforcement was closing in on him, needed a fall guy, and set Ross up. Now, this wasn't some fairy tale that the defense came up with. This was supported by the government's own evidence in thousands of pages of what's called 3500 material, which was dumped on the defense 10 days before trial. They'd had a lot of it for almost 2 years. That's like reading the Obamacare bill more than 3 times in 10 days. But they found there is evidence in there supporting what Joshua Retrial was saying. The first witness that was called was Special Agent from the Department of Homeland Security, Reagan. He had spent 2 years and thousands of hours on the Silk Road website under various aliases, ultimately becoming a high-level administrator called Cirrus. He actually helped run the Silk Road for quite a while. And the first he was questioned by the lead prosecutor, Sarah Turner, who went through hour after hour of details about the Silk Road and about all kinds of things, and Reagan answered very methodically and robotically, went on for hours. So just a tip, if you suffer from insomnia, get a recording of a prosecutor questioning a government agent, and it'll solve your problem. Anyway, it was pretty painful. But Joshua Retrial, Ross's attorney, woke everybody up with his cross-examination of the same witness. And what came out was was that Reagan, in his thousands of hours on Silk Road, had compiled a sizable amount of evidence to implicate someone else as DPR, and that was Mark Tarbells, who was the former CEO of the now-failed Mt. Gox Bitcoin exchange. I had never heard of him before at that moment. Reagan was quite convinced. He had other suspects. He had times said, yeah, there were lots of people using the DPR handle, but then he was honing in on Tarbells. And he thought he was getting very close. And he asked other agencies to please don't tip him off. I'm almost there with this guy. And in fact, he swore twice in sworn affidavits that he had probable cause to suspect him and sought a warrant for his Gmail account. The thing was, there was a lot of competition among the agencies to get DPR, to have that feather in their cap. They had that U.S. senator breathing down their neck. And there was a lot of competition to be the one. It would be quite a coup for them to nab DPR. So the next thing Reagan knows, DHS in Baltimore has tipped Tarbells off by seizing $2.9 million out of his account. That'll get your attention. Reagan was very upset. He chronicled that he felt undermined in his report. The next thing we hear is that Tarbells' lawyers approach DHS Baltimore, and they say, well, we've got a deal for you. You back off Tarbells, our client, and we'll give you a name. We'll give you DPR. And we don't know what else happened in that meeting, but we do know that 2 weeks later, Ross was arrested, and Tarbells has never been charged with anything. Reagan had never even come across Ross's name in all his thousands of hours. So mid-September was the first of 13, 2 weeks before Ross's arrest, was the first time he'd ever heard of Ross. And I don't think he was convinced that it was Ross because he kept investigating Tarbells for a while after Ross was arrested. So at this point, the whole courtroom was on the edge of their seat. It's like, wow, this is like TV. This is great. You know, we're all listening to this. And the prosecutor leaps up and he starts objecting vociferously. Stop, objection, objection. This questioning cannot continue. And the judge, you know, wasn't quite ready to sustain those objections, and she was questioning him and his line of thinking, and he kept arguing, and finally, she cut the cross-examination off. Ross's lawyer said he had about another hour that he wanted to question Reagan, held the witness over till next week, and sent the jury home an hour early in order to be able to discuss this. And she said she was doing this in the interest of justice. You know, the thing is, the prosecution had to suppress this questioning because obviously it did not quite fit into their narrative of Ross being DPR. And his lawyer, Ross's lawyer, cited the Brady rule, which is a very fundamental rule of law from the 60s, saying this questioning is valid because you cannot suppress evidence that's favorable to a defendant. And the judge agreed, it was Brady. But the prosecution kept arguing, and he goes, well, you know, Your Honor, they were trying to say somebody else is DPR. And the judge says, well, yeah, how else do you do it? And in fact, she went on to say, these are quotes from the transcript, if the agent pursued someone other than the defendant, other than Ross, not only was it highly relevant, but it was directly relevant. And how he arrived at that conclusion was obviously relevant, and that the agent believed there was probable cause was clearly relevant, and that the agent believed somebody else might be DPR is obviously highly relevant. And she then went on to say, an alternate suspect strikes me as in the heartland of the defense. And the fact that Tarbells could be a DPR has come out in spades. And when the prosecution persisted in arguing, she said, look, this Tarbells thing, that cat's out of the bag. Court was adjourned. That was Thursday. It was adjourned for a long weekend until the following Tuesday. Well, when the court reconvened, it was like a different court. Now, Reagan's testimony was irrelevant. Much of it was stricken from the record. The jury was told to forget about it, to disregard it. In addition, the court flagged questions that the prosecution should have objected to but didn't in order to sustain them retroactively. And there were a lot of new rules and restrictions on how the questioning was going to go from then on. For instance, such questions as, did you suspect Mark Tarbells? That was now off limits. Did you believe Mark Tarbells was DPR? Off limits. Did you suspect that Mark Tarbells operated Silk Road? Off limits. And about that offer from Tarbells lawyers to give DPR's name, not relevant. So, on the left is day 3, and on the right is day 4 of the trial. So what a difference a weekend makes. Totally different. So basically, the cat was back in the bag. And the reasoning the court gave, well, you know, this alternate suspect thing, that might confuse the jury. Now, I thought a jury was supposed to get all the evidence and then make a decision based on that. Not be spoon-fed one narrative. That's what I always thought. So if you can think of it like a field, and the evidence is a big field, now the defense was restricted to an extremely narrow path that was forged by the prosecution's narrative, and they could not deviate. And what Ross's lawyer explained to me is that cross-examinations are supposed to be able to explore context, to get out in that field, to get underneath the surface of the direct and bring things out. Yes, there are limitations, but this was an exceptionally restrictive set of rules. And, you know, so then, our lawyer said, we had strong issues. It would have altered the outcome of the trial. But he wasn't allowed to pursue them. So the prosecution breathed a sigh of relief. Now the thing is, if you only tell one side of a story, you can make anything sound convincing. We know that from our own lives. If you cherry pick certain things and hide other things, it paints a totally different picture than the truth. Well, once cross-examination started up again, the prosecution was going to make sure that nothing like that slipped in again. And Sarah Turner became an objection machine. And I'm not the only one that noticed it. This is a cartoon from Forbes. And he started jumping up and down like a jack in the box, objection, objection, even sometimes before Retrial could get the question out. We counted 114 objections that day. That totally interrupts the flow of cross-examination. The jury can't follow what's going on. And the question is, what are they hiding? What are they so worried about? What are they afraid of? So our lawyer, Ross's lawyer, said it was like the Titanic before it went down. It was so slanted in favor of the prosecution. He said there's no way you can crawl up on that deck. The defense was underwater, or as Forbes put it, completely derailed. Now, Retrial kept trying. He kept fending off objections, questioning witnesses. For instance, things like the fact that the laptop crashed in the middle of the analysis, other technical issues. He questioned FBI agent Kiernan about an experiment he did with the Linux kernel, which is a key part of the operating system. The court's ultimate response to that, leave the kernel. He wasn't, and at that point, oh, and then she said, if you want to get have a computer witness, call your own. And at that point, Retrial called for a mistrial because he said, first of all, I'm allowed to question this witness. This is evidence that I can question him about. And second of all, by saying the defense can call its own witness, it puts the burden of proof in the wrong place. The burden of proof is on the prosecution. The defense is not required to prove anything. He also, of course that was denied, that mistrial. He also questioned IRS agent Gary Alfred, who had done a lot of internet research. He wanted to ask him, who else did you suspect? What was your procedure? That was blocked. He had wanted about positive things he had learned about Ross, but that was called hearsay, but his other research wasn't hearsay. Another problem the defense ran into was that their exhibits and documents were blocked while the government submitted dozens during the trial. And so Retrial said, okay, if we can't use ours, we'll use theirs, but just a different section. No, he couldn't do that. And so by flooding the defense with exhibits during trial, 44, I think, in a couple of days, these are complicated documents. It was like a continuously moving target, and it made it practically impossible to have an effective defense. And in fact, the post-trial motions that have been filed cite this as one of the reasons there should be a retrial. It wasn't fair. Now, of course, this case is a lot about Bitcoin, and the government did call a Bitcoin witness, ex-FBI agent Young is his name. He now works in the private sector at a company called FTI. Now, knowledge of Bitcoin is not genetic, and just because I'm Ross's mother doesn't mean I understand it that well or can comment on his testimony. So I wanted to have somebody who knows a lot about Bitcoin do it for me. Roger Ver, who's a very well-known entrepreneur and Bitcoin investor, said, the prosecutors, he tweeted this, the prosecutors in the Silk Road trial have no clue how Bitcoin works or are intentionally lying about it. Now, this witness, he had only worked on one Bitcoin case before. He didn't do most of the work on this, and he didn't document his procedures. And for his testimony and research, his company was paid $55,000 of taxpayer money. Typical of how things were going, the defense was only informed about it at the last minute. And they said, could we have a couple of hours just to review this testimony? It's very complex. No, couldn't do it. So eventually, and Retrial moved to strike the testimony based on that, but that was denied. So the defense called its own Bitcoin witness, Andreas Antonopoulos, a well-known Bitcoin expert, author. Here he is testifying in front of the Canadian Senate. And, but he was not allowed to testify. He was blocked. One of the reasons the court gave, well, the jury understands Bitcoin just fine. This testimony would be irrelevant and unnecessary. Again, Retrial moved for a mistrial. It was denied, and he has since called for a retrial, also based on the fact that this witness was blocked. Now, I read the due process clause. It says you can call witnesses. And if you recall, the court had said, call your own computer witness. So they did. Stephen Belvin, Columbia University. He could have refuted and challenged the laptop investigation. He could have talked about things like how open ports are not secure, how timestamps can be changed, how the technology behind hidden websites is so complex you really can't prove a thing. But he was blocked. Reason? This case doesn't require technical knowledge. This is not necessary. Meanwhile, the government was allowed to present an avalanche of digital evidence that they themselves admit can be easily planted, hacked, manipulated, edited, faked. Mortgage companies won't take a screenshot of your bank statement because they know how easily faked it is. So the government had a lower standard than mortgage companies to put a man away in prison for decades. On the real life side, there was one witness who actually testified about Ross as a person. That was Richard Bates, who was testifying in exchange for not going to prison himself. He had helped program the site in its infancy. And he testified that Ross told him in 2011 that he had sold the site. Now, there were witnesses that were notable by their absence. One was anyone who came forward to say that Ross had harmed them in any way, that they had been victimized by Ross in any way. Now, my new reading material is the Federal Prison Guidebook. They talk a lot about the victim. They talk about making restitution. Nobody showed up as the victim here. Another notably absent witness was the lead investigator, Christopher Tarbell, who also works at the very lucrative FTI with the Bitcoin guy. He was the lead investigator. Oh, here he is on 60 Minutes Australia. He's talking about what a thrill it was to arrest Ross. He goes, it was better than anything you can get on Silk Road. And I'm like, really? Are you talking from experience? Anyway, he was the lead investigator. He signed the criminal complaint. He was the head of the arrest of Ross in California, and he claimed to have found the Silk Road server, and he was barely mentioned at the trial. I doubt the jury even registered that he was involved. And about that explanation about how he found the server, it was debunked by experts all over the world who said it was called gibberish, impossible, a lie. Nicholas Weaver of Stanford said it was inconsistent with reality and didn't mesh with the FBI's own evidence. But despite his key role, Tarbell was erased, totally absent from the trial. So of course then, the defense could not question him about his investigation or about the server. Throughout the trial, it became evident that you just can't know who's behind a computer screen. You cannot know who's written a chat. Just because someone sends an email from my address doesn't mean I actually wrote it. And Mike Howard, the Guardian, says, no one is who they say they are in this trial. And so another absent witness, this brings to mind, this other absent witness who was Andrew Michael Jones, who was known as Inigo on the site. He was the longest serving administrator on Silk Road. And he was going to be a witness, and the prosecution yanked him off the list. But he had made a statement that Retrial wanted to read to the jury, and it went like this. Around August of 2013, Inigo wanted to talk to DPR. But because you never know who's behind these names, and because who knows who was using the DPR username, they had set up a prompt. But when Inigo offered the prompt to DPR, he didn't know the answer. And the defense wanted to read this to the jury, and the prosecution, no, we cannot imply in any way that there was more than one DPR. And they blocked even this small slice of information being made known to the jury. And you know, about multiple DPRs, the government's own evidence shows they know there were multiple DPRs. Alex Winter, whose documentary, Deep Web, premiered here yesterday, it's a great film, told me that he interviewed people deep inside Silk Road, and even the architect of the site. They all say, oh yeah, there were lots of DPRs. There had to be, because there was so much went through that user that no one person could handle it. And besides, they had different personalities, they were obviously different ages, different attitudes. One said, well, yeah, I wanted to set up a second vendor account, and DPR said no. So I said, well, go ask the other DPR, okay? And he did, and came back and said, okay, you can have an account. They all knew that there were more than one DPR. Amir Taki told me himself that he had chatted with DPR in the early days, they had a great communication, and then about a year and a half later, chatted with DPR again. He said it was definitely not the same guy. He didn't remember the previous conversation, but also he just had a different personality, different attitude, totally different person. All these guys, Alex told me, also are firm in their belief that the DPR who wrote about freedom, nonviolence, doing no harm, was a different person than allegedly in 2013 planned murder for hire and big drug deals. They also expressed a lot of doubt, and actually many people have, that a 20-something guy with a few helpers could be running a worldwide, multi-million-dollar, 24/7 drug empire from his laptop in a cafe. It's kind of like thinking, oh, Jeff Bezos is sitting there on his laptop in a library running Amazon. It just isn't possible. But the government was sticking to their narrative and wasn't allowing the jury to see these questions. Another thing that they erased was the fact that Ross has a loving family who cares about him and that he loves. You know, in the trial, we were sitting pretty close to him, and sometimes the lawyers would go up for a sidebar. Ross would take the opportunity to turn around and make eye contact and smile at us, and we could have a little interaction, which was rare. You know, we don't get to see him much. Well, that just did not fit the prosecution's picture of what they wanted to present, you know? And so they said, no, you cannot turn around and look at your family. You have no family when that jury is in the room. So we were effectively erased. Very carefully managed narrative, censored. Another thing that they censored and erased was Ross's peaceful libertarian philosophy. That was never allowed to be mentioned. You know, it just doesn't fit the picture. And you know, even Silk Road, the Silk Road site was distorted, and I'm not here to defend that site at all. But if you were sitting in that courtroom, you would think that the only things sold on there were heroin, hard drugs, and a little cyanide thrown in. I don't remember them mentioning marijuana, which I think was one of the main things sold on Silk Road. Certainly not illegal non-drug items like raw milk, or legal items like art or books. No mention of book club or drug harm reduction forum, or certainly not the philosophy of a free market and nonviolence. That was not allowed. It was erased. The real Ross, the peaceful, nonviolent, liberty-loving Ross was erased. And instead, the jury got to hear and was spoon-fed the image of a ruthless kingpin motivated by power and money who would do anything to defend his empire. Stop at nothing. And you know, murder for hire comes in handy when you're painting that picture. And for the record, this is the prosecutor saying Ross was not charged for those murders. That's a quote, it's in the transcript. But they acted like he had been. They spent the whole last day of the trial talking about it. How could that not prejudice a jury? And the media, by the way, who loves that stuff. They weren't required to prove it or charge him for it. Now, it seems to me, if you're going to accuse somebody of something that serious, you should either have to charge them and prove it or not get to talk about it in trial. Instead, they threw up unauthenticated chats and went on about it for a whole day. And about those chats, one commenter said, the conversation feels like a badly scripted CSI episode. Another one said, the chats reek of politeness, perfect spelling, few typos, and too much description. It sounds like the same person writing to himself. And I noticed that too. I noticed it's all perfectly capitalized and no abbreviations. I'd never seen chats like that. And I went back and looked at chats and emails Ross had sent me. I could barely find a capital letter. Plenty of typos, plenty of abbreviations, but they're just a little too perfect. And Ross's lawyer said they're teeming with red flags of fabrication. There are so many questions that don't make sense to me. Another one is, if Ross was the only DPR, who was running Silk Road for 6 weeks in 2012 when he was here, in the middle of nowhere, in the Costa Rican rainforest, off-grid, with either no internet or one that can barely send an email? And I know he was there because I was there too. And so was his dad. Was he magically running this empire from the jungle? Another, there's all these little things, like I was reading the forum of DPR posts, and in November 13th and 12th, DPR, I guess, had some crisis, and said, boy, I'm going to be slamming back the caffeine tonight. Well, that got my attention because Ross never drinks caffeine, ever. In fact, I tried to get him to drink tea when he was going through discovery in the prison, and he said, I just can't drink caffeine. It doesn't agree with me. So who was that? Or how about the files that appeared on Ross's laptop after he was arrested? Or the fact that DPR posted on the forum a few days after Ross was arrested? So a whole lot doesn't add up, and as his attorney said, the narrative from the prosecution is just a little too convenient. And I believe that as far as the truth, we know the tip of a very large iceberg. But while these questions are intriguing, it's too late. Ross has been convicted. He's been convicted of 7 counts, 2 of which contradict each other. It's kind of hard to be a kingpin and an aider and abetter. You either run the show or you're helping. But he got convicted for both. And he faces sentencing May 15th. I've been told that by a couple of lawyers, different lawyers, they said, well, the prosecution typically pushes for the maximum sentence because that looks good on their resume. Well, we're talking about the equivalent of life for nonviolent crimes. And I was visiting Ross last week, and he said, a life sentence is basically a death sentence because either way, you die in prison, one just takes longer. So that's what Ross is facing, and that's what our family is facing. But what does it mean for you? Why is this important? Because a major case like this sets precedent. And precedent influences future cases, which influences law, which impacts all our lives. Rules are set, and our constitutional protections are weakened, and inevitably government expands over time. Ross's lawyer explained it to me. He said, in a major case like this, precedent trickles down very easily, very quickly to ordinary cases, and soon it's just kind of the way it is. He said it's traditional for them to use high-profile cases to make bad law. So what precedent has been set? Well, whether or not you're convinced by the government's digital evidence, the fact is that the standard for evidence has been drastically lowered with this case. Now the government doesn't have to come up with solid, authenticated evidence. They can just use digital evidence, chats, screenshots, emails. And it's impossible to prove who created them, as I said. And so now the government has a lower standard than a mortgage company. The Fourth Amendment is also implicated in this case. As it says here, a warrant requires a specific description for what is to be searched. Otherwise, if it's just a general rummaging through your things, it's a general warrant. And that is not constitutional. It goes back to our revolution, when the British would invade homes and do that. And it sparked the Revolutionary War and was the basis for the Fourth Amendment, so it's very fundamental. Well, these general warrants are the kind that they used to search Ross's laptop, Facebook account, and Gmails. It had no limits. It was a fishing expedition to see what they could find. Now, if they had done this in his house, in his desk drawers, in his file cabinets, it would be clearly unconstitutional. But because it was his laptop, it's not. I mean, this is a very important question going forward, because most of us keep our lives on our computers and phones. Another Fourth Amendment question is, can the United States legally search and seize a foreign server without a warrant, or even hack into it? And the government goes, yeah, we can do that. And even if we somehow hacked into the server, we can do that. Even though they put people in prison for doing that. Same thing. So, in the post-trial motions, Ross's attorney said they have found more evidence of what they say is warrantless Tor network surveillance, and they're calling for suppression of the server as evidence, or at least an evidentiary hearing to get to the bottom of this, and to find out if a government agent lied under oath about how he found the server. And I have the question, well, if they're lying about that, what else are they lying about? Murder for hire, maybe? Now, we don't know. We really don't know how they found the server. We do know that the NSA spies on citizens illegally, that they share that information with the DEA, who funnels it to law enforcement, who uses it to make arrests, and makes up another story to cover the fact that it was an illegal investigation, and they call it parallel construction. Hani Fakhouri of the Electronic Frontier Foundation calls it intelligence laundering. Unfortunately, our lawyer was blocked from questioning witnesses about the investigation and whether it was illegal or not, or authentic or not. One other precedent that comes to mind for me is the theory of transferred intent. And that is making one person responsible for the actions of another, in this case, a website host, responsible for crimes committed on site that he didn't actually do. And many people have said that this precedent opens up liability and vulnerability for website hosts going forward. And you can say it's Silk Road, it was drugs and blatant and all that. But tell that to Federal Express, because under the exact same theory of transferred intent, the United States government has indicted Federal Express for drug trafficking and money laundering because some of its customers used it to send illegal pharmaceuticals. I don't believe, I've heard that they've indicted the the United States Post Office. I'm not going to hold my breath on that. So, this is a statue of justice that resides in the foyer of the courthouse where Ross's trial took place. And I would pass it every day, and I would look at it, and I would just hope and pray that justice wasn't just a statue, that it was alive, that there would be justice. And I have to say, after that trial, I concluded that it was just a beautifully crafted hunk of bronze. So, the trial's over, but the fight is not. Ross is going to appeal. You know, it breaks my heart because he was optimistic about this trial, because he knew the evidence that should have come out. Now, I don't know what it is, but I do know that he had the right to a fair trial, that we all do, and it's important to defend that, because without it, we're all in big trouble. It's essential to preserve. And I also believe these precedents are very troubling and don't bode well for our freedom going forward into the digital age. So, this is a long, hard, expensive fight. We're going to do it. If you want to learn more, if you want to help, please go to freeross.org. We could use all kinds of help. Of course, we always need money. but any kind of support is welcome. And I ask this not just for Ross and us, but to push back against this government expansion going into the future. Thank you. I don't know if anybody has questions.
I have one. I'll just ask it. In the retrial, how is that going to be different? Like, can you bring in new evidence? Can you argue a different thing up? Just lay that out, please.
To be honest, I really doubt that judge is going to grant one. But if, say, in an appeal, they say it has to be tried again, let's say it was about the server, well, they would suppress the server so that evidence would not be part of the trial, for example. Or if the attorney was told, wasn't allowed to cross-examine, that hampered his case, he would be able to redo it at that trial. So it depends what they grant the appeal on. I mean, I certainly am not looking forward to trial. This terrible experience. And it's a good question. I mean,
I'm not familiar with the government's theory of power. Can you explain that to me?
I'm really not technically capable of doing that. It has to do with CAPTCHAs and saying they found a CAPTCHA when they actually didn't find a CAPTCHA. And it's, if you see Deep Web, they explain it. Sorry. It doesn't make sense to experts, I know that. And I've heard them say why, and yeah. All right, well, thank you. Okay.
I just want to say I'm really sorry if I could go through this. It's like such a travesty of justice. And, it's really troubling that this seems to be a pattern in our government's activity lately. And I mean, going back decades as well. I had a question about the trial. Did Ross ever take the stand? Or no?
No, he was advised by his attorney not to, and at one point he wanted to. Attorneys always advise clients not to take the stand, and I think even that court and those rules of the rules that the court was operating under probably would have been good. So, yeah, he didn't. Yeah, it's not just about Ross, because I go to the prison often. There's a lot of nonviolent people being kept in prison, and I think it's barbaric. There's other things that our society could be doing with nonviolent people than keeping them basically in a cage, non-productive. Their families are horribly impacted, and yeah. And 97% of people don't go to trial because they plea even to things they haven't done, because very few people win a trial.
I have one. Through all of this, how does Ross maintain his resilience and because it must be hard for him just to get up in the morning.
Yeah, how's Ross doing and everything? After the trial, it was pretty rough because, like I said, he was optimistic, and so that was a blow. And Ross is essentially a very positive person. In the prison before trial, he was teaching a yoga class, and he taught a physics class. Even during trial, he was tutoring his cellmate in math so he could pass his GED. Now he's studying Spanish so he can talk to the many Spanish speakers in there. So he tries to be positive, and but it's tough sometimes, and he loves nature and being outside, and he hasn't been really outside in a year and a half, and hasn't had fresh vegetables in a year and a half, and just being so confined and cut off. And he's not allowed email like other prisoners because one of the charges is conspiracy to hack. I guess they think he's magically going to hack into the prison system or something. And so he's doing as well as can be expected, and a lot, and he tries to maintain, as positive an attitude as he can. thanks for listening.
I have something.
Yeah.
You know, here, his mother, so I know, yeah, I understand you're basing a lot of this on emotional appeal, very emotional for you. But I wondered if, two things, if you followed a lot of federal trials, like drug trials, and you might be more accustomed to the way feds play hardball, and that you might have had a legal expert with you to help make some of the points or explain the legal precedents that decided the way things went for and against your point of view. The other one being that a life sentence is not really a death sentence. I mean, you can look at it that way, but I mean, my girlfriend was murdered in 1976 by a serial killer. He got 2 life sentences every couple of years. I had to meet with the parole board to convince them, or try to keep him in jail. So if he can get out, your son can get out.
There's no parole in the federal system.
Really?
That might be state, I don't know. And the other thing is, I did consult with Ross's lawyers.
No, I think it'd be good to have one here to, you know.
Well, yeah, that'd be good in a perfect world. I get a lawyer over here, but I did run this by his lawyer, so it's not like I'm just making some of this up. But yeah, that would be good. I can't afford that.
Yeah. Well,
I don't have the money.
Your arguments.
Hmm?
It can help make some of your arguments or not.
Okay. I was at the trial. I'm quoting from the transcript, and I ran it by his lawyer.
I followed it too.
Yeah, I was right there. Yeah, okay, good, all right. Well, was there something specific that I said that wasn't accurate?
I just know a lot of it was based on emotional
No, it's not.
response.
It's in the transcripts.
I read the transcript